We will now move to the second case on today's docket, Trial Practices, Inc. versus Hahn, Loeser, and Park, LLP.
May it please the court, my name is Don Conwell and I represent Trial Practices, Inc. This case is about a party who prevailed in a trial through the testimony of witnesses who that party falsely portrayed as mere fact witnesses, unpaid fact witnesses, but who was secretly paying those witnesses for testifying and for actively representing the party trying to win the case. From this, that party, Jack Antaramian, obtained a defense verdict and over $2 million in prevailing party fees and costs. So the issue for the court today is whether or not that conduct violates the Florida statutes and the bar rules prohibiting offering an inducement to a witness and prohibiting paying a fee to a fact witness. And if so, whether that misconduct should be rewarded with a prevailing party fee and cost award. With the court's permission, I'd like to address first the violations, and then I'd like to address the remedy.
I mean, it seems like you're trying to collaterally attack the underlying judgment. Because where we are procedurally, the real legal issue is whether those fees get rewarded for things that are not allowed by the rule, I think. What does the rule say? Does it allow fees, and then do those fees get awarded? You're asking for more than that, and I don't see a legal theory other than that.
Well, this goes to the issue of a remedy, and there must be some remedy for this. We didn't discover this until long after the time had passed for moving for a new trial. It was 2 years after the trial before we discovered this because it was never disclosed. And we discovered it in the context of the other side filing a motion for prevailing party fees and costs. And then when we finally got the detail of those invoices, we saw that what in fact they did was they took these fact witnesses and they hired them as to win the case.
Wouldn't that remedy be to attack that judgment based on fraud on the court or whatever theories you have? But we have a process in the rules for that. But that's not up here. We don't, there's a different process for that than raising an appeal over the attorney's fees that are at issue here.
Well, but there's a 1 year period in which you can file a motion for relief from judgment under 1.540. They did not make this disclosure until after that 1 year had passed. So then we're left without a remedy. So then the question for the court is, what do you do in a situation like this where it's not disclosed until after that period of time for moving for relief from judgment is passed? We would be left with no remedy. And so the issue now is, what can the court do when we know that they prevailed by hiring fact witnesses to help them win their case? Nowhere in the rules does it permit that. There are 3 exceptions under the rule.
So your theory is that because Rule 1.540 does not provide you real relief, you didn't meet the time deadline, that we should make something up and
well, I think
in this case?
I think that there are 3 legal bases for preventing them from being rewarded with prevailing party fees and costs. Number 1 is to enforce the contract provision to give them prevailing party fees and costs would give effect to a violation of public policy. This is a public policy issue. The public policy is justice shall not be bought or sold. You shall not pay a fee to a fact witness and hire someone who's supposed to play the role of a fact witness as an advocate for you in your case. That's a clear violation of the rule and of the statutes. So you should not reward that with enforcing that contract provision. The law says that the courts should not give effect to a contract where the result of that would be to further a violation of public policy, which is what happened here. Number two, there's estoppel. You know, they presented these as mere fact witnesses in the lower court. They argued that to the trial judge. They argued that to the jury. It was clear that these were fact witnesses. And the fee hearing judge, who was a different judge, examined the record and made the same conclusion, that they're all fact witnesses. So now they're taking a contrary position. They're saying, well, it was okay for us to pay them because really they were expert witnesses. They've changed their position in this court 180 degrees, and now they're saying, well, these fees were lawful because they were really expert witnesses. So, you know, they should be stopped from recovering the prevailing party fee and cost award in these circumstances where they're taking these inconsistent positions.
Are you familiar with subsection B5 of Rule 1.540?
I don't recall which
Well,
ones
I mean,
are which, but
I understand that you've got some time limitations, but there are some provisions in that rule that are not subject to the 1 year time limitation. Isn't that correct?
that is correct, yes.
And there's a provision that provides that it's no longer equitable that the judgment or decree should have prospective application. That's in there. But what you're asking us to do something here for which, what precedent do you have?
I don't have precedent other than, you know, I can say that there's never been a case like this that I've seen. All the cases that I've seen and that I've cited to the court where there's been a violation, it's been one witness or two witnesses at most who were unlawfully paid in violation of the rule. Here we've got 7. It undermined the entire trial.
Let me suggest this. We're here on the certified question. I suggest you focus on that for a while.
Well, and that's where I wanted to head.
I understand.
So
We'll let you get there.
Thank you. So I think the starting point is the common law, which is cited in the rule. And in the rule, it says that the common law rule is that it is not permissible to pay a fee to a occurrence witness, to a fact witness. The statute, the Florida legislature created 2 exceptions. Under 92.1421, you can pay $5 and you can give a mileage reimbursement. And under 92.2311, the legislature provided that you can pay a fee to an expert witness, but only to an expert witness. Now, in the rule 4-3.4b, it says you're prohibited from offering an inducement to a witness, and there are only 3 exceptions. And those exceptions are you can reimburse them for a loss for expenses, number 3, but the second one after that, along the lines of reimbursing, you can reimburse them for the loss of compensation lost by reason of preparing for, attending, or testifying at a proceeding. And then the only exception for paying a fee is the second one, and that is you can pay a fee to an expert witness. That's the only exception that allows the payment of a fee. But what the Court of Appeals said was, no, you can pay a fee to a fact witness to hire that witness to help you win your case. That completely changes the rule. It's, number one, it's not in the exceptions, but it's contrary to the intent and purpose of the rule. The intent and purpose of the rule is not to offer a financial inducement, but as soon as you're hiring a fact witness and offering them a fee, you've now made them into an advocate.
So, let me make sure I understand kind of the core argument, because if I understand this correctly, it's really pretty simple. You're claiming, and tell me if I'm wrong, that assistance with case and discovery preparation does not fall within the scope of preparing for, attending, or testifying at proceedings.
That's exactly right. And that provision refers to preparing the witness for giving testimony, not for hiring a fact witness to help prepare the party's case for trial. That completely changes the role of the fact witness from a fact witness now to an advocate. And it completely flips the rule on its head. And you might as well just throw out the rule if the law in Florida now is that any fact witness can be hired by a party and paid a fee to help that party prepare their case for trial, basically to win the case. That's not in any of the exceptions. So the certified question clearly has to be answered in the negative, that you're not permitted to do that. And to do so and to allow this would violate the public policy of this court and of this state, which has been identified in many cases. Justice shall not be bought or sold is the core principle here.
No,
And this is getting-
the people, the attorneys, they're mostly attorneys, were actually involved in the original deal that resulted in a settlement. Is that correct?
Yes.
So they, as they were preparing for the issue of, when they were preparing for trial, they were using these witnesses, I'm assuming, as fact witnesses, but taking away from their time as attorneys. Now, but for the rule, which may envision paying them for their testimony, if you're asking an attorney who previously worked and you paid money to spend days on reconstructing what happened, where is if our concern is you don't pay a fact witness for their testimony, I'm not as outraged or concerned about it in this context. So could you explain to me if you think the rule intended to bar that from happening, or is your big issue that it should have been disclosed, which we go back to, which I don't think is before us, to the jury, that they had spent, I don't know how much, we're talking about a lot of money, hundreds of thousands of dollars in preparing for what they said at trial. So can you help me with that?
Right, well...
one is the issue with the practicalities. You're asking a busy attorney to spend time with you now to prepare your case.
Right, but this goes far beyond that. And that's what the Court of Appeals was saying, is like, in addition to time you spend actually testifying and preparing for your testimony, you also can pay the witness for other services, basically hiring them as your advocate and helping you win the case, helping you prepare your case.
Let me ask this question. Are all of these, is the testimony of record exactly everything that all these witnesses did, number one?
Yes, I think essentially.
Everything is there, okay.
It is, yes.
How about in cases, for example, that there is a voluminous documentation, something like a construction dispute, high-rise construction down in South Florida, and it's just tractor-trailer loads of documents, and an expert engineer go to the engineer and want to ask facts about it. So I don't remember that. I don't remember that. Can you pay that person his time or her time to go through the records to come up with whatever the facts are in those tractor-trailer loads of documents?
Yes, the bar rule that governs our case says that you can reimburse them for compensation lost by reason of preparing for, attending, and testifying in a proceeding.
Okay,
That
so
would
you
fall
can-
under.
You can then pay a witness who would prepare the facts.
That's correct.
Okay, now how are these different qualitatively
Well,
than those kinds of circumstances?
Well, the bills that they submitted were helping to prepare a motion for summary judgment, helping to
Is
work
that what
on
everything
motions.
was acting as an attorney for the party? Everything?
Right, they're now advocating for the party. They are.
Well, not, but some of what they did, am I not correct, did fall within the scope of preparing for, attending, or testifying a proceeding.
Yes.
There was part of it that was that, but then there are these other things. And so the question is what falls within the scope of this as opposed to these other things, which the district court refers to as case and discovery, assistance with case and discovery preparation. Now, the district court said that falls within this language, and you're saying no, and I'm having trouble seeing how that falls within this language.
Well, assisting somebody in preparing their case for trial and assisting somebody in winning their case is far different from assisting
Well,
yourself in preparing to give testimony.
Were there instances where they actually helped in answering interrogatories and
Yes.
all kinds of things that were not specifically related to preparing for the testimony that they were going to give?
Yes, they helped answer interrogatories, not to them, but to the party. They prepared deposition summaries. They worked on motions in limine. They worked on motions to amend. They worked on all sorts of.
So they were really functioning, what you're saying, as attorneys.
That's
And then you, I mean, again, I understand, but you at trial, these are having to cross-examine these attorneys who you had no idea had done all this work.
right. They're being presented to us, to the judge, to the jury as mere fact
I don't mean
witnesses.
to bring you back to that, but there does seem to be something.
Right, they're being presented as mere fact witnesses, and they're much, much more than that.
I mean, but I question that assertion in the way we use the term fact witness. We use that to distinguish between experts who are allowed to give opinion testimony at trial. That's the difference, is that you can't not list someone as an expert and then elicit an opinion from them, correct?
Correct.
So they were, in fact witnesses. No one attempted to elicit opinions from them, correct?
Well, actually, Mr. Kester, who was their counsel, actually did try to elicit some opinions. We objected, and the judge sustained the objection.
Because they were fact witnesses.
Because they were
They
fact
had not been
witnesses.
listed as experts, so.
That's correct,
Okay.
yes.
You knew that these were attorneys who had done work for the opposing side, correct?
Yes,
Okay. And I would think that you knew it was a possibility that they could still be doing work for the opposing side, correct?
I suppose I was not trial counsel, but I would think that could be a possibility, yes. But they were not disclosed as experts at any time.
Do you think that if the work that they had done as attorneys for the opposing side had been in different matters, that would have been permissible for them to be paid for?
Yes, I do. I
Work
think
related to
the
different
violation is hiring them in this case. They were fact witnesses in this case. In the first case, actually, they were acting as lawyers to write a settlement agreement. But in this case, they're fact witnesses as to what happened there. And there's no rule that permits you to hire them now and to pay them a fee. The rule, in fact, is to the contrary. It says you cannot offer them an inducement. The only time you can do that for a fee is
In
for an
terms-
expert,
in
and the
terms of
expert's
the-
got to be disclosed.
In terms of the failure to disclose argument, did you ask in discovery if these attorneys were still doing work for their former client, what you knew to be their former client?
That is not in the record,
Okay.
and I didn't do it, so I cannot
Let me ask you this
answer
one.
that.
Let me see if I can ask you a question. Over here.
Okay,
I've been the quiet one.
yes, sir. Yes.
You mentioned earlier that the only fee these fact witnesses are entitled to receive, not even a fee, it basically is to be reimbursed for whatever time they devoted out of their job.
For lost compensation,
Lost
and they all said, none of them who were asked said they lost compensation. They all said they
Right.
did not
So my
lose
question is,
compensation.
if the so-called fact witness happened to be someone who is retired, not working, just living off his retirement, and is asked, just as Lewis mentioned, to review a truckload of documents and assist counsel in preparing for deposition or whatever. Under that scenario, that person would not be entitled to be paid anything.
That is correct. That is what the rule that governed during our case said. There's not an exception for that.
So who would do that?
I'm sorry?
Who would do that?
Well, the way we've always done it is you subpoena them and you ask them the questions. In fact, they did that with one of their fact witnesses. He was the lead attorney for Nassif in the underlying case. And
You
they
can get, I
subpoenaed-
mean, you can get anybody to help you with documents. The issue is, to me, I mean, do you get to tax the other side for it? So it's not like you're barred from having lawyers or whoever assist in document review. Is that one of the issues here?
No, what you're barred from doing is paying them. That's the issue.
If they're a witness, if they're a fact witness.
If I'm,
They can't be wearing these two different, the issue here is they can't be wearing two different hats.
yes,
They
I
can't be
agree.
the fact witness doing the things that are legitimate for a fact witness to do, and also, helping you work up your case and being paid for that. It's like, because that doesn't, I mean, the theory would be that that's an inducement. If you're paying them for that, it's an inducement that's inconsistent with their role of being a proper fact witness, correct?
Yes, I agree.
We've taken more than all of your time. I'll give you 2 minutes for rebuttal,
Thank you.
nonetheless.
May it please the court, Ed Kester for Hahn Loeser. I would like to begin with the rule as we get to the certified question. The rule 4-3.4, fairness to opposing party and counsel, specifically authorizes the payment and reimbursement of reasonable expenses incurred by the witness in attending and testifying at the proceedings, and further allows reasonable compensation to reimburse a witness for the loss of compensation incurred by reason of preparing for, attending, and testifying at the proceedings. The witnesses that we are talking about today are first Fran Nolan. Fran Nolan was a certified public accountant who prepared Jack Antaramian's tax returns. She was deposed after the trial by Mr. Conwell's firm, and she unequivocally testified she had no prior agreement to be paid for her testimony. She assumed she would be paid someday, but the real estate market was bad and she didn't know, and her assumption might be wrong. She testified she billed at her tax hourly rate, did not bill for a higher expert witness rate. She testified that when she was in trial, there was a suggestion by opposing counsel that Mr. Antaramian committed tax evasion and did not include income on his tax return. She said as the tax preparer, she crushed it, showed him right where the income was on the tax return.
So how many hours did she say on the stand that she spent in preparing for trial?
She billed approximately 2 days for the trial and 1 day for the deposition for a total of $11,000.
Okay, and now what is being sought for that witness post-trial
Post-trial, her entire invoice submitted post-trial to Bob Frazita, the chief financial officer for Mr. Antaramian. Her entire invoice is sought, and our contention is, it's quite clear from her invoice, that it's all for preparing for, attending, and testifying at the proceedings.
So it was only $11,000?
Correct. That's Fran Nolan, the first one, and she's a certified public accountant. So
Before you go on with going through all these facts, let's go back to the certified question. How should we answer the certified question?
you should answer the certified question in the affirmative, and the reason you should answer it in the affirmative is in our particular context, what you'll see as we go through the record, we're only going to end up talking about lawyers who gave legal advice before and after the trial, before and after the lawsuit, and most of their billing is for preparation, attending, and testifying at the
If it's
proceedings.
before and after, how is that case preparation and discovery? I don't understand that. If you're saying that's a category, and I'm asking you about the certified question, that puzzles me.
Howard Medwood, for example, with the law firm of Burns and Levinson.
Now, you're going back to these facts. I'm kind of here at this higher conceptual level, and you're talking about, I'm not following your reasoning.
On a conceptual level, if you have a professional working for you who is working for you before you get sued, and you call that professional and you say to that professional, I need help about what happened, I need to respond to discovery, I need to respond to this lawsuit, and I need your testimony to help me, that person has to educate trial lawyers, for example, my predecessor
So they're
counsel.
being paid for what? Okay, but they're being paid for something that happens after the case starts. I thought you were saying they're being paid for things that happen before the case and after the case. And now you're saying, well, after the case, they've got to help you because of things they did before the case. Right?
They're
So is it going on during the case?
lawsuits filed in 2006. Tax planner Howard Medwood and his law firm with Robert Weinstein and Mark Manning are specifically asked by Mr. Antaramian's earlier attorney, wow, this guy's claiming we committed tax fraud. Could you help me understand what happened? Burns and Levinson, their timekeepers, Howard Medwood, Mark Manning, and Robert Weinstein, write down their time, and the law firm sends an invoice. At that point, they are still Mr. Antaramian's lawyer. They're now, by contention, Mr. Conwell, that they are now fact witnesses. My trial presentation was that they're hybrid witnesses, and the court did accept my hybrid analysis, like as a treating physician, and did allow Mr. Medwood to explain the lice doily, which was the settlement agreement unraveling this complex, hundreds of millions of dollar estate between two parties, and was allowed to give his tax advice to the jury. I said he was a treating physician. There's nothing here that's surprising. Hybrid style witness. That is the type of testimony he was specifically authorized to give. Fran Nolan, for example, was allowed to give testimony regarding.
With respect to that, I mean, if you had listed any of these people as experts, these would not be issues at all, correct?
Correct.
Right. Because you can be a hybrid. You can be a fact witness, and as long as you're disclosed as an expert, those experts can consult with the case, they can help with the case, they can also give opinions, correct?
Correct. One significant thing to note about that is whether they were disclosed on a pretrial form as experts or non-experts isn't outcome determinative as to whether they fall within the rule or whether they were properly giving legal advice. The court may have concluded that they couldn't give the testimony that we wanted them to give, but the court unequivocally allowed them to give the testimony and treated them as hybrid and felt that hybrid witnesses didn't need to be disclosed as experts. For example, if it's a treating physician. And I like the treating physician example because it's clear and it's used so often. If my doctor performs a medical procedure on me and later I'm involved in a lawsuit and somebody says, well, now you're a doctor as a fact witness, he can't give an expert opinion anymore and he wasn't disclosed as
But
an expert.
we're talking about if that same doctor, if you could get that doctor to say, listen, I need you to sit down and I need you to go through and talk to my client about all of these interrogatories and help me prepare answers to interrogatories. And this is what now the independent medical expert is saying, and I want to have you help me with that. And you're still saying this is a fact witness. That's what we're talking about. We're not talking about whether you can't pay the treating doctor for the time spent to testify and whether they're an expert. So I'm having trouble again, and going back to Justice Caney's question, we're presuming in the answer that they're fact witnesses, not hybrid witnesses, in the question, right? Can they pay them for their assistance with case and discovery preparation, which is not to preparation for their testimony, but to develop the case, to defend the case? And I don't understand what you're trying to say. Are you saying the question should not be answered because it didn't happen in this case?
2 points. First point, the question should be answered in the affirmative because having a lawyer who's a tax lawyer give you advice is not precluded by the rule. And as the Second District Court of Appeals said...
Well, okay, so now you're saying what was happening, you've got $176,000 for Burns and Levinson. Were those the tax lawyers?
Correct.
Okay, and so is there a detailed accounting of what these fact witnesses, what they did for the $176,559.35?
Absolutely, and that detail accounting is in the record. The most of that money relates to their deposition and their trial testimony. There is also unequivocal time entries for when an interrogatory comes in related to
But
the tax.
we're only asked to say, so you would, if most of it is legitimate for their trial testimony preparation, and you can, then you'll be able to show back to the trial court what part is what, but I think,
Correct.
But it's not, so
My-
it may be a very small amount then.
It may be. It's not as substantial as it has had those court led to believe. It's actually quite insubstantial if I go through each of the witnesses.
Yeah, but it
my
is,
second-
I mean, it's a startling amount, $2.5 million in various costs, fees, and expenses. So we're not talking, you're saying 10,000 here or whatever. That's a startling amount of taxable costs, frankly. I mean, I've,
But
not that I've ever, that's just, we're not in the realm of what it is we normally see as judges or lawyers.
2 points. One is when an interrogatory comes in to a person who's being sued for a gigantic amount of money by a jury consultant who took a case on a contingency fee, claiming that he netted hundreds of millions of dollars or more than $100 million out of a complicated settlement agreement, and they want to know how the settlement agreement worked, and they want to know what properties which entities are which. To suggest it's some sort of crime or illicit or secret to go to the tax lawyer that drafted it, who's your longtime tax lawyer, and say, help me answer these interrogatories, Mr. Antaramian on his own would have no way to answer those interrogatories. He would have no way to explain the tax ramifications of Lace Doyley. Interestingly, the interrogatory answers that we're talking about fit directly within the exact trial testimony given by Howard Medwood, Mark Manning, and Robert Weinstein.
So then maybe that would be within the scope of preparing for attending or testifying at the proceeding.
And that's my point.
Oh, well, okay, but that's not the way this question is framed. The question is framed as assistance with case and discovery preparation. And I think that in a way that is understood to be beyond things that are directly preparing for attending or testifying at a proceeding. And so that's the way this is teed up for us, and that's what we've got to decide. It's kind of a binary choice, yes or no. And both of you seem to agree that we should answer that question. It's just you think one thinks it should be answered one way, and one thinks it should be answered the other way, right?
Correct. I would also like to add, please, that Rule 4-3.7 of the Florida Bar Rules relates to conflict. And in that context, it says a lawyer is only conflicted out for being an advocate at trial if the lawyer is going to be a witness. And I would explain and argue to the court that if you look at 4-3.4 and 4-3.7, Mr. Conwell's argument that they were shocked and surprised that Mr. Antaramian's longtime lawyers were still giving him legal advice after the lawsuit was filed, even though they were going to testify, to me is disingenuous. And the reason it's disingenuous is he knew they were involved. He knew they were going to depositions. He knew they were his longtime attorney. He knew that they were signing affidavits in response to motions for summary judgment. He knew they were involved all along. And given that the rule specifically contemplates payment of witnesses and reimbursement, given there was a venue provision that forced the case to be tried in Tampa, given they were alleging complex tax fraud, making arguments up out of whole cloth related to a complex settlement agreement, knowing that nobody lived in Tampa, knowing that the Burns & Levinson law firm is in Boston, other lawyers are in Naples, and everybody was traveling in, even the accountant, they could not possibly have thought they were walking into a courtroom where nobody in the area lived, and that all of these professionals were coming in to give professional opinion and help for free. There's no way they could have legitimately believed it. And if the court were to answer the certified question in the negative and say that a lawyer is no longer allowed to help with case preparation and no longer allowed to provide legal tax advice because his client has been sued, that would be directly inconsistent with 4-3.7, and it would be a due process problem. If my client's professionals have been his long-term professionals, they prepare his tax returns, they handle all of his complex legal matters, And if he gets sued by a jury consultant, Mr. Conwell is arguing to this court that he should be stopped and should no longer be able to pay any of his professionals, and he should no longer be able to obtain their professional advice, and that they should have to work for free. And that simply is not a fair statement of the law, and it would jeopardize.
Do you think that the rules should be different for a non-professional fact witness?
The answer would be different. It could be different for a non-professional fact witness.
I mean, should somebody sees an accident in which your client is involved, and should your firm be able to hire them to do some paralegal type work unrelated to their testimony in connection with that lawsuit or something else?
I think that would be improper, and I think that highlights the difference between these professional skilled witnesses who are longtime advisors to Mr. Antaramian and an occurrence witness. These are not occurrence witnesses.
But you recognize that the rule as drafted does not treat fact witnesses differently based upon whether they're professional or non-professional.
My answer to that is that the rule does not exclude consulting experts and lawyers providing advice to clients on a continual basis, and we would have to read all of the rules together, and that's why I bring up 4-3.7, because a reading of 4-3.4 that says your tax attorney is now disqualified would run afoul of 4-3.7 and work an unusual hardship on a client.
I should know the answer to this question, and I just don't remember, but do you have a duty to disclose in discovery consulting experts or only testifying experts?
You do not have such an obligation. Every one of these witnesses testified in deposition, every one of them testified at trial, every one of them testified truthfully. Opposing counsel did not ask any of them, and I do want to point out, did not ask any of them that they were paid, but I do want to point out that every one of these witnesses that we're talking about was introduced to the jury as to who they are. Mr. Medwood was introduced as, I'm the longtime tax attorney and present tax attorney for Mr. Antaramian. Fran Nolan, the CPA, I prepared all his tax returns, I signed his tax returns, I'm his CPA. So there is no question whatsoever that these people, as presented to the jury, were known to be his professionals. The only exceptions would be Mr. Stewart, who represented opposing counsel, or opposing party in the underlying litigation, and Mr. Faris. Mr. Stewart billed only for his time preparing for, attending, and testifying, so he's not subject to the question before us. And Mr. Faris billed for preparing, attending, and testifying, with one exception. In 2006, when the lawsuit was filed, somebody asked his firm, Robbins Kaplan, to provide document production, and he sent a couple of bills, that totaled about $1,100 for the cost in producing documents. There isn't anything in the rule that would prevent paying somebody for document production or a professional, and it would be hard for me to believe that we could be here with TPI and Mr. Conwell claiming there was massive fraud and illicit testimony because a law firm was requested to produce documents early on in a lawsuit.
Where did the bulk of the money get paid? Who got most of this money?
Burns and Levinson to break it up, about $2 million of it is attorney's fees. And it began with Mr. Chaffee, then it went with Mr. Rohn, and then it went to my office just before trial. So when we're talking about the magnitude of the number, most of it went to attorney's fees, and the client was being sued again for many, 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 many millions of dollars and being accused of all kinds of interesting things from the contingent fee jury consultant.
And the attorneys testified at trial as fact witnesses.
I think they testified as hybrid witnesses. For example, the judge let Mr. Medwood give his tax opinion. They allowed Mr. Stewart, who was also a CPA, to give his opinion on why he thought when they entered into the Lace-Doyley settlement agreement, it did not create recovery. Nobody testified as though they saw the color of a light. It all related to reviewing documents, their understanding of their professional role.
What were they listed as?
What it is they did in the preparation of the tax return, right? I mean, what they did, what were the facts of what occurred, of the underlying problem of the issue at trial?
And what was their opinion regarding whether there was gross recovery?
Right, so if you've got, doesn't that point out the nature of the problem and the reason for the rule? Is if you have those people testifying and there's that much money at stake that arose from the preparation of the trial, doesn't that point out the very nature of the problem and why that's a potential issue for the bar rule?
4-3.4 specifically says that the witness can be reimbursed for their travel expenses and reasonable expenses, and they can be reimbursed for their time spent preparing for, attending, or testifying at the proceedings. So Mr. Stewart, for example, there isn't anything about any of his invoices that don't fall squarely within the rule.
What you described a few minutes ago was a lawyer who essentially, it sounded like, almost acted like lead counsel for the litigation because of the experience and all the expertise that particular lawyer had with the client. So what your argument was, why shouldn't that person be paid and reimbursed for essentially being lead counsel on the case? But it seems like that's a problem according to the rule, isn't it?
Well, Mr. Stewart was lead counsel for Mr. Nassif in the underlying trial. If you're talking about my discussions related to Mr. Medwood was always Mr. Antaramian's lead tax attorney as far back as I know, and he was his lead tax attorney before and after the trial. If the rule were to be read that Mr. Antaramian could no longer use his lawyer, for example, when he prepared his tax returns for the next year, when he assisted him with the taxes related to his trust, he would actually be forced to fire all of his professionals.
Well,
Because
that's not, I mean, I don't think the suggestion is that they couldn't have a relation that's independent of the case. The question here is whether they're going to receive a payment for services in connection with the case. So you're expanding this beyond what is at stake in the rule, I think.
Burns and Levinson provided legal advice, and they provided preparing for, attending, and testifying at proceedings. Legal advice, I believe, is appropriate under 4-3.7, and their payment for preparing for, attending, and testifying is clearly appropriate under 4-3.4, and nobody did anything wrong with respect to Mr. Medwood. On the witness list, they were not disclosed in any particular capacity. They were not listed as hybrid or solely as fact.
But if they're this concept of hybrid is they were both an expert and a fact witness. It's a duty to disclose that. If you had disclosed them as expert witnesses, maybe we wouldn't quite be here. The other concern I have, and it's maybe this is bigger than this case, is we got a lot of legal malpractice, medical malpractice cases out there, and the role of people that are fact witnesses to what happened, whether at the end of the day you're going to use those same people to prepare and then get the other side to have to pay in the form of taxable costs for what could be here millions of dollars of preparation time. There's just something about that doesn't that strike you as not being either within the intent of the taxable rule, cost rule, as well as outside, not addressed properly in the bar rule?
Briefly explain, they brought a lawsuit against my client. They alleged my client made gross recovery as a result of a very complicated settlement agreement. They claimed that my client committed tax fraud and they should get 5% of the tax fraud. They had a very broad fee provision and they had a venue provision in Tampa. They were absolutely on notice when they brought that claim and they made these allegations that they knew these tax professionals would be involved. And I would add that these professionals were deposed well before trial. There was no court rule of any kind that said that you had to disclose hybrid fact witnesses as hybrid fact witnesses. Their testimony was all over the record and crystal clear before the trial as to what they were going to testify to.
In response to this question, in part of the answer, that you're not just traveling under the rule with respect to the recovery of cost. You're traveling under a contractual provision that you believe that's broad in scope that would cover
Correct.
this.
I see that I'm out of time.
You are.
Thank you, Your
It's clear that the rule simply does not provide any leeway to a party to hire and pay a fee to a fact witness. to help that party win their case, which is what happened here. They were hired to help them win the case. Imagine if you apply that, to circumstances you described. Any witness that comes in should not be paid a fee to help a party win a case. That's always been the law. And when the other side presented their witnesses as mere fact witnesses, not as experts, not as hybrids, and not as paid advocates, which is what they were, there was a serious lack of candor with the court.
Well, was they, again, we don't have this record, just on that lack of candor. Were the questions asked in deposition? What's been your involvement in this case?
Now, there was a requirement in the local rule that required them to disclose experts. And he's now taken the position that they were experts. They disclosed their experts. They disclosed 2 of them. And then those expert depositions were taken in November and December of 2009. These other witnesses were never identified as experts. That's
But
why
you
they're
took
not
their
hybrids.
but their depositions were taken.
So
The depositions were taken, and I did not take the depositions. I don't know, they're not in the record. I don't know what they say. But I do know that they were not disclosed as experts. And
Am I correct that if these witnesses had been disclosed as expert witnesses, that there would be no issue? Because a witness can be a fact witness and can testify and can get paid to help with the case as long as they are disclosed as an expert witness, correct?
that's right, and so long as they are in fact an expert witness. You cannot, we've cited cases in our briefs that say you can't hire a fact witness as an expert witness, and then they come up and just testify about facts and they're truly not an expert. Let me just say in conclusion that it's wrong to let someone profit from their wrongdoing. In this case, it would be like letting the bank robber keep the money. That's why we believe that the underlying judgment should be vacated, or, Justice Kennedy, we should be permitted to pursue relief from judgment. Thank you.
We thank you both for your arguments. The court will now stand in recess for about 10 minutes.
All rise.